Hello, dear friends. My name is Prabhash Ranjan. I am a professor and vice dean at the Jindal Global Law School, OP Jindal Global University in India. As you know, India and Australia have launched negotiations for a comprehensive economic cooperation agreement, which would cover goods, services, investment, energy and resources, logistics and transport, standards, rules of origin, and sanitary and phytosanitary measures. I'm going to talk about the coverage of investment in the India-Australia CECA or FTA. Since both the sides are keen to include investment issues in the agreement, it would be useful to spend some time to understand the existing positions of the two sides on the issue of investment protection under international law. As is well known, India decided to undertake a comprehensive review of its existing investment treaties after being sued by a large number of foreign investors under different bilateral investment treaties. As an outcome of this review, India took three steps. First, it unilaterally terminated its bilateral investment treaties with almost all countries. This includes the India-Australia BIT that entered into force on 4th May 2000, was terminated on 23rd March 2017. The provisions of this agreement will continue to apply to investments that were made on or before 22nd March 2017 for a period of 15 years from the date of termination of the agreement because of the survival clause. Investments that are made on or after 23rd March 2017 will not be covered by the agreement. So this was the first important step that India took. Second, India decided to issue joint interpretative notes in those cases where the investment treaties were not unilaterally terminated. Very few countries have shown interest in joining India to issue these joint interpretative notes, most notably Bangladesh. Third, India came up with a new model bilateral investment treaty in early 2016. This new model BIT, which came into existence, it scaled down several pro-investor provisions that were found in India's BITs that were signed in the 1990s and early 2000s. The model BIT has introduced several features that give precedence to states' right to regulate. For example, the model BIT provides first, taxation measures shall be outside the purview of the investment treaty. The exclusion of taxation measures from the purview of the investment treaty is a direct outcome of the ISDS claims brought against India by companies like Vodafone and Kane Energy, which challenged India's retroactive taxation measures. Second, issuance of compulsory license shall be outside the ambit of the investment treaty completely, provided that the compulsory license has been issued in accordance with the TRIPS agreement. So normally in the new generation of investment treaties, we find that several countries exclude issuance of compulsory license from the purview of the expropriation provision. But the Indian model BIT goes a step forward and it excludes the issuance of compulsory license from the investment treaty altogether. Third, the model BIT does not contain the MFN provision. Now, India decided to exclude the MFN provision after it lost a case to an Australian company, White Industries, that was able to use the MFN provision to incorporate a beneficial feature from the India-Kuwait bilateral investment treaty into the India-Australia investment treaty. Fourth, the model also contains a broad general exception clause that allows the host state to deviate from the treaty obligations when it is necessary to do so for the purposes of public health, environment, etc. And fifth, the ISDS provision, the one which has undergone a significant change, has been made more challenging for foreign investors to invoke. So, for instance, the foreign investor has to necessarily exhaust local remedies for a period of 5 years before commencing international arbitration. Now, on the basis of the Indian model BIT, India has been trying to negotiate its new investment treaties. It has been successful in negotiating a few investment treaties with countries such as Brazil, Belarus, and Mozambique. but it hasn't so far succeeded in convincing important treaty partners such as the US, EU, or even other countries like Australia, and therefore it's going to be very interesting to see whether India would be able to convince Australia about the model bit as it launches the negotiations for the India-Australia FTA. Now, will this model bit be acceptable to Australia? I mean, that's a key question because the Indian strategy is out, or at least the template is out in the open. Now, it's interesting to know that Australia too is reviewing its bilateral investment treaties. It has terminated some of its investment treaties and has replaced them with modern investment chapters in FTAs. For example, Australia's BIT with Hong Kong was terminated on 17 January 2020 following the entry into force of the Hong Kong FTA, the Hong Kong Australia Free Trade Agreement. Now, if one looks at the investment chapter in Australia Hong Kong BIT, Australia Hong Kong FTA investment chapter, which I'm taking as a representative of the Australian new investment treaty practice, one finds that it contains several provisions aimed at safeguarding the state's right to regulate. So, for instance, Article 15 provides that nothing in this agreement shall be construed to prevent a party from adopting, maintaining, or enforcing any measure otherwise inconsistent with this agreement that it considers appropriate to ensure that investment activity in its area is undertaken in a manner sensitive to environmental, health, or other regulatory objectives. So there's a clear emphasis on safeguarding the state's right to regulate vis-a-vis public health, environment, etc. Likewise, the Australia Hong Kong FTA investment chapter in Article 18 contains a GATT Article 20 styled general exception clause. So the thrust very clearly is on safeguarding the state's right to regulate. And this thrust appears to be common to both India and Australia. And this could be an important point of convergence between the two sides as they get along negotiating the investment chapter as part of the FTA. However, there are some important divergences too that we have to keep in mind. And I'll list a few of these divergences that I have studied. And of course, for this, I have taken the Australia Hong Kong FTA investment chapter as the representative sample for Australian investment treaty practice. Article 5 of the investment chapter in Australia Hong Kong FTA contains the MFN provision, which is missing in the Indian model bit. So, will India be able to convince Australia to have an investment chapter without the MFN provision? That's a difficult question to answer at this stage. Second, while the Indian model BIT excludes taxation measures completely, as I mentioned before, in the Australia Hong Kong FTA investment chapter, the provisions on expropriation and transfer of funds continue to apply to taxation measures. So taxation measures are not completely outside the purview of the investment chapter. Third, while the general exception clause in the Indian model BIT allows India to deviate for achieving public health environmental objectives, it does not contain a GATT Article 20 style chapeau. And such a chapeau, which we know from the jurisprudence of Article 20 of GATT, is meant to ensure that host countries do not abuse the exception provision. Such a chapeau is present in the Australia Hong Kong FTA investment chapter. Another very important difference that I found is that while the Indian model bit requires exhausting local remedies for 5 years before approaching an ISDS tribunal, under the Australia Hong Kong FTA investment chapter, this period is much shorter. Given these divergences and a certain degree of convergence as well, one can say that the two sides do agree on one very important point, and that is that they need to strengthen the state's right to regulate within the investment treaty. And this is not surprising because we see this as part of the new investment treaty practice, which many countries have started to follow. But despite this convergence, there are important differences as well. The negotiations between the two sides should aim to bridge these differences, which, in my view, are surely not insurmountable. I am of the view that the Australian practice is better than the Indian practice. If Australia insists that India should include, for example, a MFN provision or allow for a much shorter waiting period to investors before they commence ISDS proceedings, in my view, India should consider these suggestions with an open mind. What the Indian government will do, we'll have to wait and watch. But I do hope that FTA between the two sides does come into existence, which has an investment chapter which serves the needs of both the sides, and which strikes a balance between the state's right to regulate along with the rights of the investor. Thank you very much for listening to me. Goodbye.